My Lord, ICMIS has never been intended for experts or IT experts only. And I want to go on record, my Lord, yes, I'm not an expert in IT. But I am one of the beneficiaries of ICMIS. Because I'm a court user. All court users. Actually, I'm a court officer, not even a court user. I'm a court officer. That is one. Two, my Lord, and it's also important. One needs not to be linked to the server, but to the case. And I'm sure in this particular matter, the main session case from which the application arises is on ICMIS, and the prosecution is linked in. So whatever pleading that arises out of the main session case is brought to the attention of the prosecution before even service is effected. That is the notification I was talking. And I was asking them to be honest enough to tell this honorable court that they received the notification, which they ignored. It's not practically possible that a session case is uploaded on the ICMIS and the application filed there is not brought to their attention. It's not possible. Otherwise, my Lord, I want to sum it up. They want to impeach the validity of the pleadings on ICMIS. That's what they are seeking to do. That unless one gets physical service, they can come and claim ignorance about the matter. And that is a very serious one regarding administration of justice. The last one, my Lord, is the danger we talked about. We have not talked about Article 44. In all this we have discussed here. That should the plea taking proceed to amount to violation of not only Article 28, but also Article 44, which is non-derogatory. Rather, non-derogable, sorry. Article 44, which is non-derogable. I'm sorry, my Lord. And that should be instructive. Now, this is the very final one, my Lord, from the application. I beg to move.
So, Marth Karua and the whole team.
Yeah.
Let me ask this.
Yes.
And the state, what is your view, assuming we proceed now, orally, and we leave the application? Is it fair, or still we say the judge is not fair? Assuming, because now we are struggling, on when to file a reply, when to file a rejoinder, when, assuming you add the application, because we came here for hearing of pre-taking, isn't it? Assuming we agree now, swim with application, add it, they respond orally, and we leave this business of, is it fair to both of you? I don't know. You know, I want us to agree. So that, assuming we had come here for hearing, that was okay. But now I am saying that you are taking this one once clear, this date. So I don't know.
I think my Lord, the way to solve this is that urgent applications are not given the same time for responses as ordinary applications. And so when it is urgent, orally, you see, it's a formal application.
I agree it is formal.
And the right to fair hearing is cuts both ways. So their response on record is necessary, but the request for time.
No, that one I'm going there having.
So I'm saying, in considering the request for how long, it's the urgency of the application, and in our case we are saying.
You are saying you are not. It wouldn't be fair to proceed.
Yes. Yeah, but I'm also telling the court and the defense to remember that gentlemen who are presumed innocent, 3 of them, they are, yes. No, it's a part of it. It's part of it.
Also, you are saying that it's not fair to the same. It's not a ruling, by the way.
Is it? Yeah.
But I am concerned. Before I go to
You told me.
I would concur with senior counsel because
Thank you
if
for
they are
once.
not prepared to proceed, now one of us who are not
We are prepared, please.
But we are talking about fair. It's okay now. We can't be one
Yeah.
So it's okay now. That's why.
Yeah. They need to file, but you shorten the time. Yeah. You know.
What my colleague said. I think my senior colleague, Elias Mayor, is not a Gen Z. But issues to do with IT operate in a different way. The procedure of ECMIS, which my senior colleague is submitting as if he's an expert, you have to be linked to that particular matter before you actually access it. He knows very well that we have Data Protection and Privacy Act. These are not matters for everyone. So this application, which we haven't even looked at, we don't know whether it was even filed. We cannot.
Because just let him finish.
Okay, so by must be taken to IT class. You see, this is what we are talking about, that we have not accessed that, and we have no business. We have a lot of things to do other than looking at ECMIS, where we are not actually linked to. Because whatever, if you have an ECMIS account, whatever you're supposed to see, whatever is linked to you is what you see. You don't see what has not been actually linked to you. I don't know whether my senior colleague has evidence that DPP's office was linked to this application. I just wanted to say that and reach our earlier submissions.
Is the prayer they are making that despite the fact that there is a pending application for stay, court proceeds to administer pre-taking. That is the list that would come from the office of the DPP. I think it would be safer on their part, my lord, to first address their mind to the gist of the petition. If a party seeks an order of stay, it's imperative, my lord, that we look at the crux of the matter. In effect, my lord, an application for stay is about arresting the proceedings. And the court is duty-bound to look at the reasons as to why the party is seeking to arrest the proceeding, to halt the proceeding, bearing in mind the danger of proceeding to the next step before addressing your mind to the reasons being advanced. So therefore it goes without saying, since they have not looked at the online application and they have not been physically served, so they don't know the issues that are being raised. And it would therefore be imprudent on their part again to ask to proceed in such a casual manner. My lord, for the emphasis sake, as I conclude, had they taken trouble to look at the online pleadings, I am sure they wouldn't have made that prayer that we proceed, because these are very, very serious issues we are taking to the Constitutional Court. Actually, we have taken to the Constitutional Court. Very, very serious. Going to the root of the proceedings before you. Number one, the impartiality of this court. So anything that touches impartiality of the court is so central to the proceedings that court must be sensitive in taking any decision as to whether to proceed or not. The other issue, my Lord, with utmost respect to this honorable court, is the question of the orders being sought of the removal of a judge. These are very serious matters. And my Lord, one needs to first critically reflect on those issues before you proceed to administer a plea. And these are the issues we intend to argue out in the formal application, my Lord. And I'm not attempting to argue them out, but I was just emphasizing the point that this is not a matter that should be handled in a cursory manner. To overlook the issues that are being raised and then proceed with the plea-taking. I reiterate the prayer made, my Lord, that you be pleased. And this is the procedure, my Lord, to dispose of the application before you.
I would like to say a few things, but first to tell my learned colleague, the Assistant DPP, Mr. Jatiko, with a light note that he has no duty in law to oppose every application made on this side, especially if it is procedural.
I think this is wrong. No one is opposing any application. It is a matter which is, the same defense is placing it before the court. We have not known. So to say that we are opposing.
Let me finish why I said you are opposing. We are seeking for the court to halt the process until the stay application is heard. But Mr. Jatiko says, hear the plea first. That's what I heard you say. Unless he said that the plea should be heard. Unless if I misheard him, that is where I'm coming from. That in essence is opposing the stay. Because once the plea is heard, the proceedings will have commenced. The very proceedings we are trying to stay. And this is a procedural matter. There is an application which is going to be served at the end of the day. And on a matter, like my learned friend Arias Lukwago, the Lord Mayor has elaborated, it's on matters that have been canvassed before this court, so it's not on any new matter. So I would like to refer the court to Article 28, subsection 1 of the Constitution, about the right to a fair, speedy, public hearing before, these are the two operative words, independent and impartial court, if I may leave there. That is the area the accused persons are contending. They want their petition before the High Court to agree with them, or disagree for that matter, their contention that they are not before a fair, an independent and impartial court. They have given their reasons. So this is an Article 28 fair hearing issue, and therefore the stay of proceedings is critical to that extent. We would pray, as has been canvassed by my colleagues, that these proceedings should not continue until you dispose of the stay application.
That statement expand from the record. But it's important just to make sure that we have a guided procedure so that we don't have to respond to each and every.
Yeah. Yes, that the petition before the High Court is to determine these issues, because the recusal was about impartiality. The reference to the court, which the court rejected, was also about the same issues. So the gist of the application, that is what is before the court for trial. I would also say it's already been canvassed that asking for 1 month is unreasonable. And I would like the court to note that although they are asking we go for plea, committal was in May this year. We objected because we had an application for mandatory bail on that day. But nevertheless, since the date of committal, we have not been served with any bundles to be aware of even what we are pleading to, even if it were to come to that. So if my learned colleagues are in such a hurry to go where when even the bundles are not with us? Because if it was the hurry for the hearing, and they should, because the trial should be speedy, to show that they are keeping to their lane and within the law, by now, without us asking, the bundles should be with us, so that the accused are even able to know what they are being asked to plead to. So I'm just asking the court to note those few points, and to also reminding the court, needlessly though, that even at this court, at this chance, on your own motion, you could initiate admitting the accused persons to bail. It's within your powers. Yes. Especially after knowing that they are now been behind bars for 1 year. We are going to 1 year, 1 month. So even as we canvass all this, it is within your powers, my Lord, to admit them to bail, especially because the sureties are before you.
Court. Counsel Subuga Simon for A3. My Lord, the petition before the Constitutional Court, as highlighted by Senior Counsel Ernest Kalibala, soundly speaks about impartiality as stipulated in Article 28 of the Constitution. My Lord, this greatly impacts on A3 as well. In that regard, A3 wholesomely does associate with the prayers of counsel for A1 and A2. And my Lord, when you are pleased, we shall use the time you are going to grant to serve any further documents to the state for response. We so pray.